Good evening. Welcome to this Bar Standards Board webinar on our latest future bar training consultation. My name is Vanessa Davis and I'm the Director General of the Bar Standards Board. I'm joined this evening by my two colleagues, Ewan MacLeod, our Director of Strategy and Policy, and Julia Whitting, our Supervision Manager. Let me start by telling you how we're going to run the webinar. First of all, my two colleagues will present about the consultation. They'll cover the guiding principles of future bar training and they'll give you an introduction to our work and key issues in the consultation. At the end, they'll tell you about our next steps. After that, we'll move into a live question and answer session. I'll tell you a little bit more about how to ask your questions when we get to that point. We have many people logged in this evening covering a wide range of interests. Some students, some academics, some practicing barristers, some people involved in the running of chambers and other places where barristers work. You'll have lots of different interests. Please do keep the questions coming. If you are using attendance at the webinar for your CPD, we think that this webinar will help you develop your understanding of how barristers will be trained in the future and will enable you to make an informed contribution to the current consultation. I'm going to hand over now to Ewan MacLeod, our Director of Strategy and Policy.
Thank you, Vanessa. The principles that guide our reforms of bar training are accessibility, affordability, flexibility, and maintaining high standards. Now, I'll describe briefly what we mean by each of those terms. We want to be less prescriptive, encouraging flexibility so that the training system enables innovation in how education and training is delivered. We envisage up to 4 different types of training pathway being available, and we will work with other regulators to clarify how our training requirements align to the extent that there's common ground. We want to improve accessibility so that the best candidates can succeed at the bar, whatever their background, so that the bar as a whole can better reflect the communities it serves. We want to bring down the cost of studying for students or reduce the level of risk they're exposed to when investing in the training, so we want to improve value for money overall. And of course we want to maintain high standards at the bar by ensuring entry requirements and assessments continue to be robust. Now, one of the main ways we'll assure ourselves of high standards is by specifying the outcomes required of training pathways. People may already be aware of the professional statement, which we published the final version of last year following a previous consultation. The professional statement describes the knowledge, skills and attributes that all barristers are expected to have on day one of practice. We expect the statement to be used by training providers to develop their educational materials, learning outcomes and assessments. It will underpin all the training pathways and our quality assurance of them in order to ensure consistency of training outcomes. I want to turn now to briefly outline the structure of our future bar training programme. For those familiar with the project management terminology, this work is formally managed as a programme with a programme board chaired by one of our barrister board members, Justine Davidge, who also chairs our Education and Training Committee. As you can see here, there are a number of projects that sit below the programme, which will ultimately result in an application to the Legal Services Board for approval of new rules and the implementation of a new framework to authorise and quality assure bar training. We're also thinking now about how we'll evaluate the impact of the programme, and we'll be identifying some key pieces of evidence and indicators that we'll be able to track over time to check that the reforms are having the desired impact. I'll talk about some of these work streams in a bit more detail now. We have used external experts and our own staff in the development of the authorization framework. Historically, we have had tightly prescribed requirements for training with the Bar Professional Training course and previously the Bar Vocational course, followed by the familiar pupillage model. When the board made its decision to allow a more diverse range of pathways, we needed to create a means of assessing proposals for new courses in a systematic way. The draft authorization framework is therefore available as an annex to our current consultation. It begins by setting out the pathways that the board approved in March 2017. The first substantive section sets out what the four guiding principles mean to ensure a common understanding of the principles that should underpin all proposals. This is followed by a section that sets out what we expect to see, the indicators of compliance that will assure us that proposals meet the required outcomes. These have provisionally been split into mandatory and recommended, and we're consulting on whether we've chosen the right mandatory indicators. It's important to say at this point that just because we don't say something must be done, that doesn't mean it can't be done, and we need to change our mindset on that. We would, however, be looking for any proposals to be justified based on the four principles that I've outlined. A further section of the authorization framework is currently in development. This will be the list of documentation that will need to be provided to assure us of compliance. Once we are satisfied that an organisation has met all requirements to the specified standards, we will approve them as an authorised education and training organisation to deliver the pathway that they have proposed. For universities which are familiar with common models of accreditation and validation, the requirements and processes are likely to be very similar to those they're already familiar with, and the documentation readily available. We recognise that organisations wishing to offer just work-based learning may welcome a simplified version of the authorization framework, setting out only those matters which apply to them, and we intend to provide this. The development of the authorization framework is an iterative process and will need to respond to the findings of the consultation and to discussions held at the Education and Training Committee and our board. One of the indicators under high standards will be that the content and assessment of training must be appropriate, and we intend to continue to prescribe some aspects of the curriculum and assessments. On curriculum and assessment, we have a working group made up of senior staff and expert advisors. We want to ensure students are learning things at the right time in their training and that they're being assessed at the right time and in the most appropriate manner. The professional statement is what barristers need to meet on day one of practice. The review is trying to ensure that students can develop and demonstrate the required competences to an appropriate level for their stage of training. The four guiding principles of accessibility, affordability, flexibility, and high standards are at the heart of the review. We want to have a level of prescription that allows providers to be innovative, creative, and flexible in their provision, but also ensuring standards are high. We don't want to make changes for the sake of it, but we're also looking to challenge the status quo. This working group is looking at compulsory courses during pupillage, so advocacy, practice management, forensic accounting, but not the pupillage checklist. And that's being looked at as part of the pupillage pilots, which we'll discuss a little later. At the academic stage, we've said that the foundation subjects will be staying, but the group is looking at EU law and the divergence in English and Welsh law to work out where these best fit. And in relation to provider set assessments, a set of proposals have been put to BPTC providers and the INS based on the review work done so far. We've had some really valuable discussions at the BPTC Provider Forum already. We're also engaged with current and recent pupils and pupil supervisors, as well as current BPTC providers and the INS, and this engagement work will continue. Looking now at the academic stage, we'll be asking for input from legal academics through bodies like the Society of Legal Scholars and the Committee of Heads of UK Law Schools, and we'll also be looking in more depth at the compulsory pupillage courses. I want to say something about our approach to the consultation overall. As a matter of good regulatory practice, we need to go back to first principles and ask whether the arrangements that we have are fit for purpose. What has worked well in the past may well still be the right thing in the future, but we need to test all the areas where we impose prescription to satisfy ourselves that it remains necessary. What is the minimum regulatory intervention needed to ensure public protection? But just because something is no longer mandatory within our rules doesn't mean it will be prohibited. Now, a good example of where we've taken this approach is in relation to the role of the Inns of Court. The Inns play an important role in the education and training of barristers, and they will continue to do so. As part of our regulatory arrangements, the Inns conduct fit and proper person and educational checks when a student joins an Inn. They oversee student conduct. They administer qualifying sessions and some additional training during pupillage, and they call students to the bar. They also play a vital role in providing strong foundations for the community of practice at the bar. We think this is important, providing the link between learning the law and its application as a student and becoming a professional who's responsible for behaving ethically, usually in self-employed practice. So taking the approach I outlined before, we've asked a number of questions in the consultation designed to confirm which elements of what the Inns currently do need to be mandated in the new framework. As I said before, we're not saying that the Inns should not be doing any of these things, but we need to establish the regulatory rationale for doing so. So our consultation considers whether there should be regulatory oversight of students, and if so, by which body, whether student membership of an Inn should continue to be mandatory, whether the Inns should remain responsible for admission checks and student conduct, and whether the qualifying session should remain, and if so, in what format and who should provide them. Now next, we want to move on to summarise what the consultation says about pupillage, and for that I'm going to hand over to Julia.
Thank you, Ewan. So we're taking steps to encourage a wider range of pupillages and other final stage training opportunities to be made available. So, for example, the board has already said that it would be prepared to consider, for example, an apprenticeship model if an interested provider comes forward. Therefore, we need to examine all aspects of our existing regulations to ensure that the rules that we prescribe are necessary, appropriate and proportionate. And we're aware that the current rules surrounding pupillage are relatively rigid, so we're committed to introducing greater flexibility. Any new framework of rules for work-based learning must meet the needs of both chambers and the employed bar and allow new types of training to emerge. So the rules that we're considering include the mandatory length of pupillage. So should we allow pupillages to vary in length and not be fixed as they currently are at 12 months, split into 2 periods of 6 months non-practicing and 6 months practicing. So organisations offering pupillage may want the flexibility to tailor their training plans to better suit their needs, but our current rules don't permit this, as they require that all pupillages are fixed, as I've just described. And related to that, we have questions around when we'll award the provisional practicing certificate.
So at the moment that's awarded at the end of the first 6 months, but should we have greater flexibility in when and how that's awarded. We're also, in the context again of flexibility, asking questions about the one-to-one relationship between the pupil and the pupil supervisor. So should we allow pupils to supervise more than one pupil? Should we remove our requirement that a pupil supervisor can only supervise one pupil at a time? Some pupils have a number of different pupil supervisors during their pupillage. Should we remove the requirement that pupils have a single name pupil supervisor and instead require the organisation and put the focus on the organisation to ensure that all pupils are adequately supervised throughout their pupillage? In relation to the principles of affordability and accessibility, we're considering the level of the minimum pupillage funding award. So we're asking, should that be raised from the current level of £12,000 a year? That's below the minimum wage, or the national living wage, as it is now. And there's evidence that people from lower socio-economic backgrounds can't afford or are put off from entering pupillage. But we also recognise the potential impact for chambers and others, particularly those who undertake publicly funded work. So we're asking whether you think the minimum pupillage award should be raised, and if you do, what benchmark should we use to set the new minimum level? Looking at the principles of maintaining high standards, in this context, many organisations providing pupillage have never been through a formal authorisation process with us. We're considering a light touch system of reauthorisation for all organisations, and we're considering how long before an organisation is required to be reauthorised under the new authorisation framework, and that will apply to all types of training organisations, including those providing pupillage. We're also looking at whether we should prescribe the outcomes for pupil supervisor training and whether pupil supervisors should have to undertake refresher training. And we're considering whether pupillage training courses should be opened up to a wider pool of training providers. As you mentioned earlier, there are some other pieces of work that we're working on at the moment in addition to the consultation questions that we're asking. So we have a piece of work at the moment looking at the implementation of the professional statement, threshold standards and competences as a means of assessing pupil competence. So we published the professional statement in 2015, and after a period of consultation, the supporting competences in 2016. And in the future, all pupil training will need to be designed to meet the newly defined competences in that professional statement. We're rolling this out on a pilot basis this year and next, together with a more in-depth approach for supervision of all organisations that provide pupillage training, and that touches on the principle of high standards. If you're interested in getting involved in that pilot, we're interested to hear from you, particularly for providers outside of London, and particularly for chambers and the smaller chambers in particular. Another piece of work that we're currently just getting started on is in relation to recruitment and advertising. So we've set up a task completion group because during previous consultations, concerns have been raised that access to pupillage is the single biggest barrier to increasing diversity in the bar. And also some of the employed bar say that the advertising requirements create barriers to offering pupillage. So, as I say, we've established a task completion group which is reviewing recruitment and advertising practices and identifying exactly where those barriers are. So finally, before we move on to the questions, just to highlight the next steps. The consultation is open until the 8th of January. The decisions that we will take regarding transitional arrangements will be made by the end of May 2018. application to the Legal Services Board for any rule changes will take place late 2018, and there will be a further round of consultation specifically on the rule changes. And the earliest time that we will be authorising new routes to qualification will be in January 2019.
Thank you very much, Julia. So everybody, that's the end of our presentation on the consultation document, and so it's very much over to you. I'm here to moderate the question and answer session. You should be able to see a purple button, ask a question, on your screens, although if you've got your screen in full screen mode, apparently you won't see that purple button. So shrink your screens and then you'll be able to type in a question that we will see. Now, I may need to group questions around a single topic, so do listen out for your topic. You will not be identified personally to the audience in any way. Although I will, in effect, play your question back, I will not do so in a manner such as to identify you individually. I should say that if we don't actually get to your question today because of the volume of questions, then we will make every effort to send you a personal email response as far as we can before Christmas. So I'm going to jump straight into the very first question that's been asked, and this clearly comes from a student. The question is, since we all know the importance of ADR, that's Alternative Dispute Resolution, globally, and in UK in particular, why is the redoc exam not conducted on a practical basis? Since from the academic standpoint, students are not learning practical skills, and practical skills are the foundation of the BPTC. Well, this is obviously straight away a very technical question, and it's a question, of course, that to a great extent the Curriculum and Assessment Review Group is dealing with in the consultation. And if I may, because I'm actually a member of the Curriculum and Assessment Review Group, I'm going to have a first stab at answering that question. So the first point to make is that clearly in the consultation and the review, in practice everything around what's assessed on a vocational component of the training is up for grabs. So we will be considering views about what are the best things, the things that need to be covered in order to meet the requirements of the professional statement. And if those things need to be covered in the curriculum, what then is the best and most effective way of assessing them? It's not really helpful to go into the background of the current rules and where we got to and why redoc is assessed in that way, but I would want to assure that the person who answered that question that we are very alive to the importance of dispute resolution within the curriculum. You'll see it expressed in the professional statement, and we are committed to find the best and most effective ways of assessing people's skills and their knowledge in relation to ADR, and we're quite sure that ADR will continue to be of great importance globally. Julia or Ewan, is there anything that you want to say about that in as much as it reflects this principle of using the professional statement as the basis for looking at barristers' competence?
Well, just that really. Yeah. So we're looking at all of these arrangements at the moment. At the end of the day, what we need to be producing is a barrister who satisfies all of the outcomes that we've specified in the professional statement. There might be various ways of assessing those outcomes, and one of the things the Curriculum and Assessment Group is looking at is the relative balance between centralised assessments and assessments that might be conducted by the providers. Yeah. And we want to make sure that we've got that balance right.
Do you have anything to add at all?
Well, only that there have been very lively discussions along the lines of the questionnaire. So, absolutely, as Vanessa said, these are very much part of the discussion. What should be assessed, how, yeah, and at what point?
Absolutely, and from the Curriculum and Assessment Review Group, I think it's fine for me to play back that one of the considerations that we have is that resolution of disputes out of court, ADR, is significantly a skills-based kind of competence, being able to get that under your belt. And so we need to think about what is the best environment for acquiring those skills. And it may be that we haven't got the balance right as between what's happening in the classroom during the vocational stage of training and what's happening perhaps in the more real live environment of work-based learning and pupillage. So that's the kind of balance that we'll be trying to do. So another question that we've got, again, I'm pleased to see that students are asking questions. Will the 5-year time limit of obtaining pupillage be extended? Julia, what are the people looking at pupillage saying about this kind of issue?
That's not part of the consultation, so I'm not aware that that's currently under discussion.
I mean, the principles behind that, of course, is that people's knowledge of black letter law and their exposure to the skills training that they have in, for example, the vocational stage shouldn't get too stale before they're able to carry on. But what do you think, Ewan?
Well, I think that's a good example of a level of prescription that we impose at the moment.
Yeah.
And we need to be able to test whether that remains necessary. And, you know, the reason that you give might be a good reason for keeping that rule. Or we might want to take a more outcomes-focused approach in the future. So that will be something that we need to ask about, although it's not specifically gone into in detail as part of this consultation.
Okay, so what I would encourage that questioner to do is to answer the consultation and put forward your views so that we can take them into consideration. The next question is also in some ways quite technical, and the questioner will forgive me if, in addition to reading the question out, I do a little bit of explanation for other members of the audience. This question comes from somebody working in a law school. Can you clarify whether the bar will continue to recognise a degree as a so-called qualifying law degree? The 7 foundations of legal knowledge continue to be required, though I understand changes to what's known as the joint statement are due. Could the full position be explained? Many thanks. Well, I hope very much to be able to help the questioner, even though I should say right at the outset, I can't give you a complete and definitive answer quite yet. A bit of background for other people listening. The joint statement is something that was entered into by, as it were, the predecessor organisations of the BSB and the Solicitors Regulation Authority, the Bar Council and the Law Society, way back in 1994, and it hasn't been revised since 1995. And effectively, that it said that for a degree to be recognised as a degree that could contribute towards becoming professionally qualified as either a solicitor or barrister, it must contain certain things. And this is where you get this notion of the 7 foundations of legal knowledge. Both we and the Solicitors Regulation Authority have said that we want to step back from the way in which we regulate what happens at a university level in relation to law degrees. And I'm going to ask Ewan shortly to say something a little bit more about how that demonstrates our overall regulatory approach and where we should have what kind of touch within the system. But on the specifics of this, in part the question arises because the SRA's proposals for change to legal education and training are focused on not actually prescribing anything that happens prior to the point at which people take and must pass what's known as the Solicitor's Qualifying Examination. The Bar Standards Board, in contrast, has said that it will expect a candidate for call to the bar to be able to demonstrate a sufficient grasp of those 7 foundations of legal knowledge to the extent as that being expressed in our professional statement. So we will no longer, as such, be recognising a degree as a so-called qualifying law degree, but we will have some requirements out of programmes and people who've been through programmes to demonstrate that they actually do have that kind of knowledge under their belt. We are working with the SRA to make a new statement. The working title is a common protocol rather than a joint statement, so that everybody's clear that it's something new, that we can publish to everybody in the new year, and that will make the position very clear. I could simply say to the questioner, who does come from a specific university, I will get in touch with you directly after this broadcast and give you what further information I can, and indeed I'll be very happy to come and talk to you at your law school to explain the situation more fully. Ewan, there's something here about the overall BSB approach. It's actually quite important for people to understand. Would you like to explain a little bit about that?
Yeah, so I think fundamentally what we want to be is more outcomes focused and focusing purely on assuring ourselves that at the end of the training program, trainees have met the outcomes that are set out in the professional statement. We don't really want to get into a level of detail of telling law schools how they should be teaching law. Frankly, the law schools are best placed to know how to do that. But we do want to make sure that people understand what are the areas of knowledge that we expect to be delivered as part of the professional statement, and we would expect that to continue guiding the general areas of law that the law schools teach.
I think that's quite right. There's something about us making sure that we focus our regulatory resources and efforts at the point closest to where we have our public protection role, which is actually at the point of authorisation and the practicing certificate, not so much what's happening in a law degree. Absolutely. I think another important point is that if you do go back to that quite old now joint statement, those 7 foundation subjects only ever had to occupy 180 credits within a degree programme. So we think that there's still plenty of scope within the system for keeping the foundations and innovating as well. But as I said earlier, we'd be very happy to talk to the law school that asks that question. Moving on now, there's a question now that's from Chambers, and the question is, I'd be grateful if you could explain in a little more detail the procedure for becoming an authorised education and training organisation. I'm going to hand this one to Julia, and perhaps Julia, you would also in answering this, explain to people a little bit more about what you do if you're already a provider of pupillage and how we will be interacting with you in the future. Thanks, Julia.
Yeah, so the current process, which is still in place, is that you would need to make an application to our authorisations team, and the information about how to do that is available on our website. The process at the moment involves providing some information about, for example, your pupillage policy, the way that pupillage is structured and managed, or the way that you propose to do that. As Ewan talked earlier about the authorisation framework that we're in the process of developing, and I mentioned about the fact that pupillage providers at the moment will not necessarily have gone through an authorisation process. So those that were providing pupillage at a certain point in time were grandfathered into the current process, and therefore will never have gone through any kind of authorisation process. Those who applied to become providers subsequent to that will have gone through the authorisation process that I've just described. We are looking, as I said, reauthorisation, which will be a light touch process, really so that we can get a good base of information, a baseline of information about who is providing pupillage at the moment and who wants to provide pupillage in the future, and that we, in the context of maintaining high standards, have a certain base level of information about those pupillage providers. I'm involved in the project that is looking at the authorisation framework in the context of those who will continue to offer pupillage, and I am looking at the type of evidence that pupillage providers will have to provide us with in the future in order to become authorised. And it will look different to the current process, and it is particularly set out in the context of those 4 principles that we've been talking about, which are behind everything that we're doing with future bar training. So accessibility, affordability, flexibility and high standards. So that's part of the consultation, which if you have a look at the consultation document, you'll be able to read more information about it.
Thanks for that, Julia, and I would encourage the person who asked that question, if you don't get what you need out of what we've set out in the consultation document, don't hesitate to get in touch with us directly. So a final question from a student now before I move on to a completely different topic, and that's the Inns of Court. But just before we move on to talking about the Inns of Court, there's a question that asks, can you clarify the position of the bar transfer test, the BTT, in relation to international lawyers? Do employers or the BSB regard the BTT in a similar fashion to the BPTC? Is the standard the same? So there is a specific segment of the consultation document that sets out what we expect to do by way of the arrangements for recognising lawyers from other jurisdictions who want to transfer to the Bar of England and Wales. So I would refer the questioner to that section of the consultation. I don't think it's for me to comment on whether employers regard it in the same way. If somebody has passed the test and any other requirements that we have laid down in order to be authorised, then as far as the Bar Standards Board is concerned, if we have authorised someone, then we've authorised someone, and there's not much more to be said about that. Ewan, would you like to comment further on that?
No, I think that's absolutely right. And one of the important points to make about the future system, where we'll have a number of different pathways to qualification, is that we at the BSB need to be satisfied that the standard is the same across all of the pathways. And our quality assurance systems will be set up to make sure that people will be in a similar position regardless of which route they've come through.
Good, thanks for that, Ian. Now I want to move on and cover some questions about the Inns of Court. And here's one. The Inns of Court have done a great job training barristers for centuries. Who are the BSB to start telling them that they've got it all wrong? Ewan, I'm going to back that one straight to you.
Well, I don't think we're telling them they've got it all wrong to start with, but the Inns have obviously made a significant contribution to training barristers, and they still do, not just in delivering the training, but in helping to introduce students to practice at the bar and developing this sense of what we call a community of practice. And I think we made clear in the consultation that we're not trying to get rid of those elements in the system that work well and add value. But as I was saying earlier, if we want to be a proportionate public interest regulator, then we need to ask what genuinely needs to be prescribed by us, and do the arrangements that we have in place remain fit for purpose. So we need to review these things that have been in place for hundreds of years to ask ourselves, are they still the right arrangements for the future? And to go back to another point I made earlier, just because we're not mandating something, it doesn't mean that it can't continue.
That's right. Anything you want to add from that, Julia, at all?
No, I don't think so.
I mean, you've been taking our consultation out on roadshows as well as I have. How have other people been responding to our questions about the role of the Inns?
I think that from practicing barristers, there's generally a feeling that what the Inns do adds value. Some people feel that the Inns have a lot to offer in terms of social mobility, particularly for people from what you might call a non-traditional background entering the profession. The experience of being involved with the Inns, going to the qualifying sessions and dinners and so on, helps people to develop networks and networking skills that will help them in their future profession. I think that some people who are practicing outside of London maybe think the balance between London and the regions could be redressed a bit. I think some people are not necessarily convinced that we need quite as many qualifying sessions that we have at the moment. But I think there's a general consensus from the practicing barristers that I've spoken to, certainly, that there is continued value there, and that we need to be careful that we don't lose that kind of collegiate quality that the Inns can bring to training. That
certainly came through to roadshows I was present at, but there were some questions about the extra cost for people who are living outside London that may be a bit taken for granted, and that may be being a barrier. Come on, let's go straight to it. The one that hits the newspaper headlines, dinner. People suggest that the BSB is questioning dinners. This is a question, by the way, that someone sent in. Dinners may sound old-fashioned, but don't you realise the vital role the Inns have in helping people to network professionally? And that really matters most for people from a non-traditional background. I think to some extent you've answered that, but has the BSB got something about dinners that it doesn't like?
No, I mean, there's nothing wrong with the inns having dinners, and whatever we do, the inns can continue to have dinners. I think that the key point for us is whether the qualifying sessions, rather than dinners per se, have to be required in our rules. And in the consultation, we want to understand a bit better what the benefits of the qualifying sessions are, so that we can form an informed view about the extent to which we want to continue to mandate it in the future. And as I said before, a number of barristers are telling us that there are real benefits for students in going to these qualifying sessions. I think one comment I've heard a few times is that if it's just about having dinner, then that's maybe of less value than the more educationally focused sessions like advocacy training and guest lectures and so on. So I think we'll be interested in if they continue looking at what the more focused educational aims of the qualifying sessions might be.
Okay, so I've got one comment here that somebody sent in. It's not a question, it's an observation, but I will play it back for everybody. And the person sending in the comment says, I really love the inns and their differences. 12 qualifying sessions are not enough. Well, it'll be interesting to see whether other people agree. But thinking more about qualifying sessions, another question is that the BSB suggests that qualifying sessions could be provided by third parties, so somebody other than the inns. What evidence do you have for that? And I know you've done most of the work on this, so do we have any evidence?
When we were partly looking for evidence in the consultation, so I think the point of the consultation is to ask whether they could be provided by others, and we don't really have a view on that yet. But I think in particular, we want to understand if something would be lost if they were being provided by someone else rather than in a kind of collegiate way by the inns as they are now. I mean, it's of course possible that they could be done jointly by the inns and others if, in order to promote sessions being available outside of London, for example.
Certainly when I've been out at consultation meetings, the idea that perhaps the inns and the circuits collaborating could work. And of course we do know already that there's significant collaboration, particularly in some circuits, between the circuits and the local law schools.
Yeah.
And I don't think anything that we would want to do would want to get in the way of that, because those are very effective collaborations.
I think I'd also say one of the things that's kind of coming across in the comments that people have made is that if getting to what would be lost if we didn't mandate these sessions, I think some people feel if they weren't compulsory for everyone, then potentially the people who chose not to go to them might be the ones who would benefit from them the most.
Yeah.
From an additional support and maybe social mobility perspective. So we're keen to kind of tease out objectively what it is that the qualifying sessions are offering from that point of view.
Excellent. So do make sure when you send in your consultation responses that you do give us as much detail and evidence based on your own experiences or other research sources or whatever as you possibly can, because we are really hoping that you will do that. I want to move on now and ask some more questions about pupillage. So some questions have come in grouped together in relation to pupillage. And the first one is one that I know that will concern people listening. The question is, there's already a risk that pupils get exploited. Won't liberalising the rules increase this risk? Julia, can you talk to us a little bit about this?
Yes, and this is definitely something that people have raised in the course of discussions on the various roadshow events that we've been holding. Particular concerns that those where potentially the pupillage experience could be better as it's provided at the moment, and people potentially may take advantage of rules to exploit the pupils if the rules are freed up. But I think the new authorisation framework will help us to assess those providing pupillage in a much more robust way in the future. And if we are liberalising our rules, we will be looking at the way that pupillage providers plan to deliver their pupillage experience through the new authorisation framework, and also through the process of supervising pupillage providers. So we're looking both at the authorisation framework and at our programme for supervising pupillage. And in the context of the latter, we're particularly interested in views of those where we're piloting the supervision programme to make sure that we're targeting the right questions when we're visiting chambers and other providers of pupillage, so that we're focusing on the right risks to pupils and to the quality of pupillage provision.
That's great, thank you for that, Julia. Is there anything more that you want to say about the pilot? Can you just perhaps explain to everybody listening the range of different providers of work-based training that we've got in the pilot already, and say a bit more about who else we would like to come into the pilot, in case there's anybody listening who would be able to step forward?
Yeah, so we've had particularly good take-up from the employed bar at the moment, and we've already started the pilot off, which includes actually piloting the rule around freeing up the one-to-one relationship between pupil and pupil supervisor. So we've looked at their organisational structure, their governance arrangements, and we're testing out allowing pupil supervisors to supervise more than one pupil at a time. So, as I say, the employed bar has been particularly interested in getting involved. We've had some of the bigger London chambers who've signed up to the pilot. And just to remind you again, the purpose of the pilot is to look at the implementation of the professional statement, so how competences are assessed during the course of pupillage. And that's looking at the professional statement rather than using the checklist that we currently require in order to evidence that pupillage has been satisfactorily completed. So we're talking to a number of other chambers outside London and some other parts of the employed bar as well. And our aim is to get a good range of geography, types of pupillage providers, employed bar and chambers in the mix, so that we get a really good cross-section of experience in implementing the professional statement, and as I said, also in testing out our supervision programme to make sure that it's really robust and we're able to review whether high standards are being maintained.
Julia, thank you for that. And so if there are chambers in particular or work-based learning providers outside London who are listening, do get in touch and tell us how we can help you take part in this pilot. But hidden in what you said was actually an important point, Julia, about the professional statement. So I just want to make sure that everybody listening is quite clear about this. The professional statement is not out for consultation at the moment. The professional statement has been consulted on over the last few years and is a fixed element of the BSB regulatory framework now. Some of you, if you're already practicing barristers, will be familiar with it in relation to the new CPD scheme, for example. And if you are listening from a law school, particularly one that's already providing the BPTC, you of course will already be familiar with it. And we know that many training providers and indeed students are successfully restructuring how they present, for example, their learning outcomes and how they understand their training path in relation to that statement. So just to be clear, we're not consulting on that now. We've already done that. Implementing the statement has to happen in any event, irrespective of where we end up on these specific policy questions relating to the Inns of Court and indeed pupillage. Let's talk about the money. Questions coming in now. How can you raise the minimum pupillage award when there are already too few pupillage places? Ewan, can you start talking a little bit about this? Because I know we did a lot of research about this. What do we understand about this and where do we think this is going?
Well, I mean, we think there are strong arguments for reviewing the level of pupillage awards. I mean, it's remained constant for several years and the cost of living has been increasing in that time. We don't necessarily think that raising it will reduce the number of pupillages, but obviously that's something we want to hear about from people responding to the consultation. I think I'm trying to remember the figure we quote in the consultation. I think that there are a number of figures that we got from the Pupillage Gateway about the level of pupillage awards at the moment, and 35% of them are less than 20,000. Now, I'm not sure what proportion of those are at the minimum, but I think that it would be a minority of those, and that's something we want to get a bit more detail on. But looking at the position for pupillages overall, we don't think that an increase will have a huge impact. But if people think that's wrong, then please do respond to the consultation and tell us.
Do that. I mean, one thing that came out of another consultation meeting when we were discussing this particular question was that many chambers, particularly outside London, seemed to be unfamiliar with the matched pupillage funding scheme that is operated by the Inns of Court. So if you are from a chambers and you're worrying about how you could meet the cost of funding a pupillage, or indeed any slightly increased cost if the policy decision takes us in that direction, if you don't know about the Inns match funding scheme, do get in touch with them to find out. I'm going to ask, there's one final question in relation to that minimum pupillage award, and then the question that's come in is, shouldn't the award be different in different regions to reflect differences in living costs? Doesn't the consultation say something about that, Ewan?
It does. So one of the things we suggested is that we might track the Living Wage Foundation, which specifies a different rate for London as opposed to the rest of the country. Yeah. And we're keen to hear what people think about that. So as an example, the national figure for the Living Wage Foundation is around 15,300, but the figure they publish for London is closer to 17,800.
Okay, so that would take us a little bit higher. And on the basis of the figures you've got at the moment, how many, what's the percentage of awards that are already above that?
Well, it would be, we know that 65% on the pupillage are already above 20,000, so it would be more than 65% that are already above that.
So whilst there will be areas where the impact could be of concern, it's possibly less than people might imagine. But do respond to the consultation, give us your facts and figures, and the facts and figures in the regions where you study and work, so that we are best placed to make good decisions when we come to make those policy decisions in the spring of 2018. I'm going to move to I hope it doesn't come across as too randomly, but I do want to pick up on further questions that have come in that I don't necessarily group in any specific areas. So the next question I've got, I should say that the questioner sent in quite a detailed commentary around their question. But if I understand it correctly, and this is a question from somebody who clearly works in mediation, the question there I think is a really interesting one for us as a regulator, and at the heart of it is, would you consider authorising a new role such as a mediation advocate? For example, someone with a qualifying law degree who's undergone sufficient training in advocacy and can undertake elements that deal with the many small claims areas of law, so consumer, family, housing, property, benefits, disability, school admissions, employment, etc. And then the mediation advocate would be able to demonstrate competency in those areas, might, for example, be able to charge fixed fees, but would be authorised by us, possibly have not quite as many qualifications as the historic fully qualified barrister. Now, what do we think about this, Ewan?
Well, in theory, we could.
Yeah, it's a really interesting proposition, isn't it?
I mean, it's obviously beyond the scope of the current consultation.
Indeed so.
But if it's something that we think about from time to time, particularly in relation to unregistered barristers, for example, because we have an issue with significant numbers of people doing the BPTC every year. They get the qualification and become a barrister, but they don't necessarily go on to practice, or they may go to other jurisdictions. So we regulate those people to a more limited extent. So one option would be to review over time what the regulatory arrangements are in relation to the unregistered bar. Theoretically, we could create an additional title different to barrister that had different rights or different reserved activities that it could do.
Yeah. So there are possibilities around this. Obviously, we would have to be satisfied that the public knew what it was getting, as it were. And one of the interesting things about this proposition is when you look at that and match it to what we know and understand about unmet legal need. And that's particularly the case since changes to the legal aid system. For example, the numbers of people appearing in front of the kind of tribunals that are reflected in the areas of work that the question has asked. Many people are there as litigants in person and probably could benefit from assistance and ideally from people who know what they're doing. Possibly that might drive down the cost of legal services for those people if there were others available to do that. So I think it's a very interesting proposition. As you rightly say, it's strictly speaking outside the confines of the current consultation, but that shouldn't stop anybody sending in views. We're always looking for new ideas. There's a key theme in the consultation about innovation.
Yeah, and certainly the role of unregistered barristers and the scope of our regulation of them is definitely something we want to come back and look at some point in the future. Not in the next year, but maybe within the next 3 years.
Yeah.
And that's a good idea that we can feed into that review at some point.
Indeed, thank you. So we're coming almost to the end of the questions, but there's one here that takes us right back to an extent to where we started, and it reflects the impact that our consultation and indeed the consultations that the Solicitors Regulation Authority has undertaken in relation to change in the legal education and training system. And it goes to, if you like, some of the concerns about change in universities and in particular their law schools. And the question is, what will the future status, recognition and regulation of the GDL be? For people listening, the GDL is the Graduate Diploma in Law, sometimes known in other contexts as the CPE, the Old Common Professional Examination. And the GDL is essentially a fast-track postgraduate diploma in law that focuses almost exclusively on those 7 foundations of legal knowledge and is available to people who are already graduates in another discipline. It is in fact a very popular training route for the bar. It's the route I chose myself. It's the route that about 50% of people doing pupillage these days have in fact taken, qualifying in getting a degree in one discipline and then doing a graduate diploma in law afterwards. So what will the future status be? What will the recognition and regulation be? So from the Bar Standards Board's point of view, if university law schools come forward with propositions for training for the bar which include something that looks like the current GDL, then on the face of it, as long as all our other requirements are met, there's absolutely no problem about that. My own view is that the market for that type of qualification will remain buoyant. Many people will still want to do that. What I think may need to happen more frequently is the integration of such a programme into a wider recognised qualification. When we talked at the beginning about reducing risk and making better money for students, what's very important is that people qualifying have got a skill set, a qualification that has currency in as many possible markets as can be achieved, because clearly the market for being a barrister is a very, very small market. So again, I don't see that there's necessarily any big changes. It will be possible for the BSB to be involved in that, and any law schools who are thinking about changing their programmes and want to understand what it means for them should get in touch with us, and we will do so. We're coming very much to the end of our time with you now. I think we've covered all the questions. I'm just going to turn to my colleagues and ask if there's any burning point that they would want to add before we run out of time and go off air. Ewan, is there anything you'd want to add?
No, just that at this stage we're very open-minded and we're keen to hear as many different views as we can. So please do respond to the consultation or send us an email at the address that's on the screen now.
Great. Anything from you, Julia?
Well, it's just good to see such a range of people involved in this webinar. And that's what we're looking for, a range of responses to the consultation. So as Ewan said, do respond to the consultation.
Great. Well, thank you very much to both of my colleagues, but most importantly, thank you to all of you for participating in the webinar. Thank you for your lively questions. Thank you for quite a few of the comments that came in, some of which were thanking us for actually putting the webinar on in the first place. Regulators don't always get much thanks, and so I should say that we were very pleased to have those comments. So thank you to the people who took the time and trouble to leave those. Do please get in touch with us if there's anything further you want to understand about the consultation before you send in your response. You can see now on the screen in front of you the Future Bar Training email address. It remains only for me to say again, thank you to all of you, thank you to my colleagues, and good evening.